The history of insurance, as we found, began with marine insurance. So, this is the first and the oldest form of insurance. So, we'll discuss the very definition of marine insurance as provided under the Marine Insurance Act of 1963, and it provided as under Section 3. A marine insurance is a contract of an insurance, is a kind of an agreement whereby the insurer undertakes to indemnify the assured in the manner and to the extent thereby agreed against marine losses, that is to say, the losses incidental to marine adventure, as it is provided under Section 3 of the Marine Insurance Act of 1963. So, the very meaning of marine adventure is also defined under Section 2, subsection D, as any adventure where any insurable property is exposed to marine perils, the earnings or acquisition of any freight, passage, money, commission, profit or other benefit or the security for any advances, loans or disbursement is endangered by the exposure of insurable property to marine or maritime perils. Also, any liability to a third party which may be incurred by the owner or other person interested in or responsible for insurable property by reason of maritime perils, as it is defined under Section 2, subsection D, and Section 2, subsection C provides about the definition of insurable property as to include any ship, goods, or other movable which are exposed to maritime perils. So, maritime perils also is being defined under Section 2, subsection E of the Marine Insurance Act of 1963 as the perils consequent on or incidental to the navigation of the sea, that is to say, perils of the seas, fire, war, and perils of pirates, thieves, and in case of any captures and seizures, restraints, and detainment of the princes and peoples. So, perils of the seas refers only to those accidents or casualties of the sea and does not include the ordinary action of the wind and waves. And as such, Section 24 of the Marine Insurance Act of 1963 defined about marine insurance policy as a contract of marine insurance which must be embodied in a marine policy which may be executed and issued at the time of the conclusion of the contract, or as is generally the case. Afterwards, by initiating the insurer or underwriter. So, Section 25 of the Act enlists the very contents of a marine policy. So, it specifies that in a marine policy, the name of the assured or some person who effects the insurance on his behalf, also the subject matter and the risks insured against, the voyage or period of time, or both, as the case may be covered by the insurance, the sum or the sums insured, and the name or names of the insurer or insurers. A marine policy must be signed by or on behalf of the insurer or insurers. And we found there are different types of marine insurance policies. So, among the very different types of marine insurance policy, the first one is voyage policy, where the contract is to insure the subject matter at and from a place or from one place to another or others. The policy is called a voyage policy. And besides that, another type of marine insurance policy is the time policy. A policy that covers a specified period of time is called time policy. And as it is defined under Section 27 of the Act, a time policy cannot be taken for a period more than 12 months. It may, however, contain a continuation clause providing that if at the end of the period the ship is at sea, the policy will continue till the safe arrival of the ship at the port of destination and for a reasonable time thereafter. In case the risk attaches under the continuation clause, a fresh policy duly stamped and covering the period in question must be taken. So, a contract for both voyage and time may be included in the same policy as provided under Section 27 of the Marine Insurance Act of 1963. And as another kind of marine insurance policy is valued policy, and it is provided under Section 29 of the Act. A valued policy is a policy which specifies the agreed value of the subject matter in the absence of fraud. The value is conclusive as between the assured and insurer except for ascertaining constructive total loss. And Section 30 of the Act provides about unvalued policy. This is a type of policy under which the value of the subject matter is not specified but is required to be proved or ascertained in event of the loss subject to the limit of the sum insured. And besides that, another policy that we found is the floating policy. A floating policy is a policy which describes the insurance in general terms. It leaves out the name or names of the ship or ships and other particulars to be defined by subsequent declaration. The subsequent declaration or declarations may be made by endorsement on the policy or in any other customary manner. So, these are the different types of marine policies as provided under the Marine Insurance Act of 1963. And now, here it is a question in regards to marine insurance who have insurable interest. So, those persons who have insurable interest are owners of ship for full value, owners of cargo, also mortgagee of a vessel. He has insurable interest to the extent of his mortgage. So also barely in respect of property left in his custody and care, and also the shippers and their agents, an underwriter for the risks insured by him which he may reinsure, and also master or any member of the crew of a ship for his wages. So, these are the persons who have insurable interest. So, there are certain other duties that, as provided under Section 19, a contract of marine insurance, like any other contract of insurance, is a contract requiring utmost good faith. If the utmost good faith is not observed by the either party, the contract may be avoided by the other. And another provision of the Act as provided under Section 20 regarding duty of disclosure, which provides that the assured must disclose the insurer every material circumstance which is known to him, is deemed to know everything which he ought to know in the ordinary course of business. A circumstance is material if it would influence the judgment of a prudent insurer in fixing or determining whether to take the risk. So, in that regard, we found certain examples such as of the very material circumstances. So, in that connection, we would like to discuss one leading case, Associated Oil Carriers Limited versus Union's Secretary of Canton in 1907, decided by the King's Bench, cancelling the nationality of the insured when such nationality is important. So also, in another important leading case, Russell versus Thornton in 1869, it was held that the fact that the ship had developed a leak before the insurance was effected. It is also falling under the very clause that must good faith. And in another important leading case in 1874, the Queen's Bench held that in Eonits versus Pindar, that the fact that the goods carried on the ship are grossly overvalued when the ship is insured. So these are the instances which are falling beyond utmost good faith. And as regarding that, we would like to discuss as per the provision of section 21 of the Act, where insurance is effected through an agent, the agent must disclose to the insurer every fact which the assured himself ought to disclose, and also every material circumstance known to the agent, as it is provided under section 21 of the Marine Insurance Act of 1963. And regarding representation, as provided under section 22, in addition to his duty to make full disclosure, the assured is under a duty to see that every material representation made by the assured or his agent during the negotiation for the contract is true. If any material representation be untrue, the insurer may avoid the contract. So, in that connection, we would like to discuss some other provisions under the Marine Insurance Act of 1963, and that is relating to the voyage and deviation. So, as per the provisions of section 45, when the place of departure is specified in the policy, the ship must sail from that place. If it sails from any other place, the risk does not attach. So also, as provided under section 46, where the destination is specified in the policy and ship sails for a destination other than the one specified, the risk does not attach. So also, unless the policy otherwise provides, if after the commencement of the race the destination is voluntarily changed, the insurer suggests to be liable as from the time of change of destination voluntarily, as provided under section 47 of the Marine Insurance Act 1963, and as section 50 of the Act provides unreasonable delay in the prosecution of the voyage discharges the insurer from its liability. So, these are the provisions relating to marine insurance. So, in detail, we have discussed almost all the kinds of marine insurance as provided in the Marine Insurance Act. And now we'll discuss exactly the provisions under section 17 in regards to assignment of policy. So, a marine insurance policy may be assigned by endorsement, or in any other customary manner. Assignment may be either before or after loss. The assignee can sue in his own name and can defend an action on any ground available to the assigner. The transfer of the interest in the subject matter does not transfer the benefit of the policy to the transferee unless terms expressly or impliedly so provide, as it is provided under Section 17 of the Marine Insurance Act. So also would like to discuss marine losses. In order to recover loss under a marine policy, the following conditions must be satisfied. One is the loss must have arisen from any of the accepted perils, and the peril must be proximate or direct cause of the loss. This is called as the principle of causa proxima, and a special rule in marine insurance for assessment of damage and the responsibility of the insurer. So a loss may be a total loss or a partial loss. And total loss may be actual total loss or constructive total loss. Actual total loss occurs when the subject matter is actually destroyed, lost, or irreparably damaged. So also when the ship is missing and no news is received after reasonable time, actual loss may be presumed as it is provided under Section 58 of the Act. So, these are the losses. And besides that, partial losses also. In regards to a particular voyage, loss is a partial loss of the subject matter insured, caused by peril insured against, and which is not a general loss. So, particular average does not include particular charges. Particular charges are the expenses incurred by or on behalf of the assured for the safety or preservation of the subject matter insured, other than general average or salvage charges as provided under Section 64 of the Marine Insurance Act of 1963. So, in relation to that, we would like to discuss the very provisions of Marine Insurance Act, and in particularly the conditions under which a general average contribution can be claimed as such. Regarding the sacrifice or expenditure must be prudently and reasonably made, and it must be voluntary and not accidental. It must be really and truly a sacrifice, throwing away something which has already become useless is not a sacrifice. The ship cargo and some portions thereof must have been actually saved thereby. The loss must be the direct result of the General Average Act. So, the very instances of General Average Sacrifice and General Average Expenditure Act, landing of cargo to lighten ship in distress, also scuttling the ship to avoid destruction of the whole of the ship, expenses incurred, and commissions paid to raise funds at the port of refuge, and the wages paid to the non-members of the crew for pumping out water from the ship. And as regarding general average contribution, all those who benefit by the General Average Act must share the loss or expenditure. As for example, the party on whom the general average loss falls is entitled to rateable contribution from the other parties interested. Such contributions is called general average contribution. So, we have discussed almost every aspects relating to the Marine Insurance Act of 1963 and which is the first kind of insurance in the history of insurance that developed and originated in the form is that marine insurance. And as already we have discussed, both fire insurance, marine insurance, except life insurance or the contracts of indemnities. So, we have completed our lecture on marine insurance. As previously already we have finished the two other most important insurance such as life insurance and fire insurance.